You are now live.
We are now live. Okay, I don't, yep, there I go, popping up on that screen. All right, so we are going to go on. I moved 437, which is that kind of mini omnibus bill that's been sitting around since last year, but the House would like it. And we're going back to an act relating to utility construction work sites and consumer protection. And FX Flynn is here and Irv. And then I'm told that we have Sarah Davis from Consolidated, but I don't see Sarah here yet. So FX, we haven't asked you to come in because this all came partly out of the incidents in Thetford and the cows and the wire, Tunbridge, sorry. And didn't ask you in because the last I'd heard, EC Fiber was somewhere in that lawsuit and didn't want to put you in an awkward position, but you emailed me and I said that you are not in that lawsuit, you've been released, and that you would be happy to talk to us. And I think, we've been talking about how we had farm family that was injured. They had to come up with money to solve that injury. There either was or wasn't insurance in place. There's been talk about bankruptcies, and it's in court. And this couple is still waiting for a settlement. And I think the concern is, how do we speed this up so that an injured party could get justice sooner? I'm not sure, given the American insurance industry and court system, that that's possible. But there's been things about people didn't have insurance and we should require they have insurance. And I thought, if you can help us understand who had what when, that might help us understand what's going on.
Hey, yes, happy to do that, Senator Cummings, and thank you for the opportunity to come and speak with you. I want to say that, EC Fiber has been willing to talk about this regardless of the fact that we were party to the lawsuit, and I did testify to judiciary even when we were still involved with that. And that was okay with our counsel as well. So I just want to say that I'm happy to answer any questions and clarify a few things. I think I just want to make a couple of key points, though, before we get into that. And number one, the contract that EC Fiber has with ValleyNet, who is our design, build, operate partner, and the contract that we have as a district with our operating partner, ValleyNet, and with our principal contractor, Eustis, which is really one of the crown jewel companies in Vermont. That contract, very, very strong. It even went beyond the provisions that are, indicated in S-166. So unfortunately, even if that language were in the books right now, this whole event could still have transpired. And so I've been thinking hard about, is there some kind of legislative solution that would have more rapidly helped out the Hoyts? And having been, inside and observed how things played out from the beginning of June last year, when we first became aware of it, which was also 18 months after it had happened in the first place. It's pretty clear to me that early communications between the Hoyt farm and presumably the initial responsible insurer, didn't happen quickly at all, or effectively from the point of view of the Hoyts. And so in trying to think about how that might be solved, it occurred to me that we have a workers' compensation system where if somebody is hurt while they're working, the state will immediately make a payment and will begin making payments to help that individual. But then the state turns around and goes after the third party that might be responsible. And they'll subrogate the insurance claim to the responsible party. And they take on the burden of pressing the claim with the underlying insurer. So the injured worker doesn't have to go through all that. But think about the Hoyts. There's a situation where it appeared that their farm business had been damaged as a result of these third-party activities that they were not, contractually a part of or had any relationship. Well, how did the Hoyts even know how to find out who the insurance company was that would be processing their claim, right? And why would anybody at Eustis necessarily take up their their side and push on it? So ultimately they had to go and find an attorney who would then present a claim, get it in front of the insurance company, which happened in January of 2021, which itself was 4 or 5 months after the Hoyts, realized they had a big problem, and after they had already spent tens of thousands of dollars. So, I really think that there might be a model there, and I'm really not sure who in state government or in the legislature could really be a point person on sorting that out. But my idea is that there would be a state agency who would be in a position to evaluate a claim from a family farm like the Hoyts, who had suffered this kind of loss, and immediately make available to them funds to cover the hay, funds to cover the vet bills, things like that. And then they turn around and go after the insurance company. And when there's a state agency that's calling up an insurance adjuster, I feel like there's a little more balance in the scale than it's when it's, a dairy farmer, in Vermont. So that's the idea I'm throwing out there. I haven't put any time or effort into trying to figure this out. That's really not, an area where I have any real expertise. But I do think that some mechanism like that could go a long way toward, providing a solution in situations like this, which I hope, we don't ever see again. And I think that this story is something that's going to last in the utility industry for decades in this state. And I think people are going to really be on their toes now to, be on the lookout in situations like that. So so basically that's where I'm at. Irv may have something to add. And then I would like to answer any questions that you may have. And I'd really like to clarify things like there's no bankruptcy, all the insurance companies are still involved, and that EC Fiber, has been actively pressing for people to sit down and talk this out without having to go through a lawsuit that's going to take years.
Okay. The bill as it came to us has it under consumer fraud, I believe. Workers' comp it seems like a more logical model. I don't think we're going to get it done in the next 2 days, which will delay things, but hopefully we can't fix what's already happened, and hopefully there won't be anything else immediately. But that I think is an interesting kind of it's. But basically here, everybody had insurance, so the bill that says you have to have insurance wouldn't have changed anything.
Everybody, if I may, everybody had, but the status of the insurance of the subcontract, the fly-by-night outfit that actually did the harm and that hadn't renewed their insurance at the time they did some of their harm, that's been one of the big questions. But the whole process this has gone through has highlighted the inappropriateness and inadequacy of the traditional adversarial structure of the way things like this are worked out. FX put hours and hours into trying to get the different insurance companies to talk to each other about making at least a partial immediate payment to the Hoyts. And almost everybody was ready, but the attorney the Hoyts had engaged is accustomed to pressing automobile injury claims and could see a wonderful jury trial option here. Well, that doesn't get the Hoyts made whole anytime soon. So that's why his idea of following the workman's comp model is so brilliant, in my opinion, too. And I also wanted to emphasize from the beginning, we've understood and felt awful about this is a tragedy for the family involved, a family farm. It's a small business. They've invested their hearts and lives in this. And I've never been a farmer myself, but I kind of imagine that the cows were part of the family too. And it's really been painful for us to see this process grind as if, it's like Bleak House by Dickens, Jarndyce and Jarndyce. And the lawyers have a big laugh when all the money in the estates have been spent fighting each other. But the Hoyts haven't been made whole.
Yeah.
Okay, Senator Hardy, you have a question.
Yeah, so thank you, Irv and FX. I'm confused though, because you contradicted each other, because FX has claimed that everybody had insurance and everything was on the up and up. And then Irv, you said actually the subcontractor hadn't renewed their insurance and wasn't insured at the time that they did the wrong.
They did the.
May I clarify?
Yeah, please do. I'm sorry.
Okay. The Fibergenesis, Kramer O'Connor Fibergenesis, their policy was canceled for non-payment on the second to last day they were on the job. So out of the, I don't know if it was 7 days or 10 days, but their insurance was in effect up until the last day or the second to last day that they were actually working on that. And so you can imagine, one of the conversations between the insurance company for Eustis and the insurance company for Fibergenesis is hey, if this happened as we all imagine it did, and it comes back to you, you're still going to be on the hook because you were the insurance coverage was in place. And the insurance company initially denied the claim, not because they had looked at the claim and they had decided it was ridiculous. It was that the owner of the company didn't cooperate. And so that's a violation of the contract that he has with the insurer, is that the company is required to cooperate with the insurer. And then also they said that the damage to the cows happened after the wire was dropped. And at that point, the policy was canceled. So that was another reason why they weren't going to cover it. But they never said, we're not going to cover it because the insurance wasn't effect on the second to last day. That was just, a factor they mentioned. But the reason they denied the claim was, number one, because the contractor did not cooperate with their investigation, which obviously began with them talking to the people that did the work. And number two, because their claim was, yeah, maybe you dropped the wire, but the cows didn't eat it for 6 months. So by the time the damage actually happened, we were not, insuring. And
Okay, so when I originally proposed this bill and started drafting it, my goal was to make sure that companies that are stringing wire across private property, or frankly any property, did good workmanship and also cleaned up the messes that they made. And so in talking about how do we ensure that you all clean up the messes that you might make on somebody else's property when you're stringing fiber or wire or whatever, there was another instance where a subcontractor left chemicals on somebody's property and goats ate it. So it's not just about the wires. It turned into a conversation about insurance, because the way that we were attempting to get at this was through consumer protection and insurance coverage. But the bottom line is that we want you all to not hire contractors who are going to do shoddy workmanship, who aren't fully insured, who are not going to cooperate when there becomes a problem and all that. So this is the first time I've heard of the potential for looking at it like workman's comp, but that really puts the onus on the state to deal with it. And I want the onus to be on you guys to deal with it. You're the companies that are doing this work, and you need to make good on the fact that you're on other people's property, whether they're farmers or not. And to make sure that you're not leaving behind things that are going to be harmful to animals, to people, and to the environment. And so however we get at that was the intent of the bill. And I don't think going down this rabbit hole of who was insured and who wasn't has been as productive as we could have been, but your solution doesn't actually get to the idea of how do we ensure that you're not going to be doing this kind of thing. But again, and if you are, that it gets taken care of quickly and equitably and fairly.
I can certainly say that the contract that we have was quite specific in a number of places, that the cleanup was required, that everybody, all the subcontractors had to have insurance. So from the perspective of the district entering into contracts with professionals to get this work done, that was all front of mind from the very beginning. And that's been true since we let the first contract out to put things up. And we've built 1,600 miles of network over the last 9 years. And we've had this happen. And I know that there was the incident with the chemical on the pole. And these two incidents are 2 incidents too many. However, I do believe that generally speaking, the people who are out there doing this construction work, they do understand what their responsibilities are. And, they do pick up after themselves. And I don't know how to, make sure that an accident never happens, or that people always do their job as they're supposed to do. I mean, and that's, in the end, that's why you have insurance, and that's why you have a legal system, is because sometimes people don't do their job, and sometimes accidents happen.
Senator,
Okay. Senator Hardy, you,
Yeah, I just feel unsatisfied.
Senator McDonald.
FX, just, EC Fiber does not install, or does it install, fiber on regulated telephone and utility poles? Does it or does it install fiber on those poles?
EC Fiber owns the network, but EC Fiber, the East Central Vermont Telecommunications District owns the network, but we have no employees or equipment or anything like that. We are completely dependent upon our operating partner and
No,
principal contract.
you're not in a partnership with EC Fiber. They're your contractors, are they not?
No, the East Central Vermont Telecommunications District does business under the trade name EC Fiber. We contract with ValleyNet Inc., a nonprofit internet service provider, to design, build, and operate our network and perform all the business functions that are incident to EC Fiber.
So did
and they,
ValleyNet enter into a contract with the
With Eustis, that is
with
co-signed,
Eustis Cable?
but it's a three-way deal. It's signed by the district, it's signed by ValleyNet, and it's signed by Eustis.
So Eustis Cable had a contract to put up fiber,
Yes,
Correct.
and then they went out and hired a subcontractor.
they subcontracted it out to an LLC out of New York.
Did the contract that you had or with Eustis Cable permit Useless Cable to subcontract it?
Yeah, only if they did it with people who had to follow all of the contractual provisions that we had with Eustis, and including having insurance and including cleaning up after themselves, etc. The contract is very strong on that point.
And did their contract say in the contract that if the Eustis's subcontractor failed in its obligations, that Eustis would have to pick up the tab for this?
Well, that's implicit in the contract. I don't think that there's any language like that. That goes into the if there's default, if there's lawsuit, that they indemnify us, right? So in the contract, if any problems arise out of the work, Eustis indemnifies ValleyNet and EC Fiber.
so, in other words, we signed a contract that had it been obeyed, obligated all the other parties to do the responsible thing.
Of course.
And the fundamental question is, what do you do when you encounter, what happens when there's a bad apple that ignores the contract the bad apple has signed a contract and doesn't follow that contract's obligations?
So what did the contract that you had with Eustis Cable say about the problem you just mentioned?
It required them to clean up. It required them to carry insurance. and it required them to clean up their work site.
They
and
is
that's
Eustace,
more-
right? They
That's
is
the Eustace.
Eustace?
And in turn, it also required them to lay all those requirements onto anybody with whom they subcontracted.
So my question is, if they were required to clean up and do everything, but they had your permission or authorization to further subcontract it,
They didn't ask
then
about.
in that case, who was responsible according to the contract you signed with Eustace?
Eustace is responsible for managing the subcontractors and making sure that they are following all of the provisions in the contract, including cleaning up after themselves and including having insurance. So that this is why Eustace's insurance company is also heavily involved with what's going on to get this resolved.
Does the contract that you have with Eustace Cable authorize them not to pay off until after they, Eustace Cable, has gone to court, or must they pay off first?
There's no
Before
contractual
going to court.
provision. No, there's no contract. That's just not how that really isn't how it works. Respectfully, when the Hoyts presented their problem to Eustace, Eustace did not I think they didn't understand the full dimension of it until they got the letter from the attorney. And so initially they were helping the Hoyts out with some payments for hay and so forth. But I don't think they recognized it, and I don't know when they actually got their insurance company involved, and this began to become a bigger thing, right? And I wish to God that I had heard about this, right from the get-go, because the second I heard about this, the very first thing I said was, we've got to alert our insurance company. What's going on with the insurance companies? Why hasn't this been taken care of yet? This all, this happened. This was discovered as a problem in late summer of 2020. Why am I hearing about it for the first time on Saturday of Memorial Day weekend of 2021? And why am I hearing about it? Because it hasn't been solved yet. Because this seemed to me to be clearly a case that the insurance companies would jump in and get resolved promptly. And and then it was you find out one thing after another about the the subcontractor, and and people just letting things play out, right? That's what was very frustrating about it, and that's why I spent all of June, July, August into early September trying to get these people marshaled into a room together to say, okay, let's get together with the Hoyt's attorney and let's start getting this solved.
So what this committee seeks to do is to prevent the situation that you have shared with us. And I would ask the chair of this committee to say perhaps we would like to be able to have the person contracted to put the stuff on the publicly regulated poles be responsible for any subsequent subcontracts, so that we don't have to horse around and wait for settlements that we know are going to come in the future when similar responsibilities go unmet.
Well, listen, I honestly believe that if somebody who has had some experience in the insurance company, like I've had, I was the CIO of a homeowner's insurance company down in Rhode Island. Somebody with that level of experience being aware of this, could have pushed the appropriate parties harder and faster and sooner and gotten it done. That's why, so who's going to do that? You can't expect the Hoyts to do it. You can't expect folks at, the contractor to do it. You can't expect folks, in the, operations department, at ValleyNet to do it. It's got to be somebody who appreciates what the issues are and, what the dimension of it is and understands how insurance companies work and think. That's why I'm coming up with the idea about the workers' comp, and that we're just talking about solving the problem. As far as preventing it, I wish to God we could legislate that people do their job well every day, because that would eliminate a lot of issues like this.
I think if we're gonna deal with this, we're gonna have to talk about contract law and insurance law. It sounds like the insurance was there, but it is the nature of insurance companies, because they want to keep their premiums low, and we want to keep them low, to argue over who's to blame, and that takes time. We are a litigious society, and I don't know, some things you just can't legislate, like clean up after yourself. Usually you put a penalty in there if you don't. But I don't know that would have helped the Hoyts either. And that's what insurance is for, is to pay them for their damage. I'm still trying to, the reason we did workers' comp is so that the worker got paid and then the insurance companies bought it out. And there was a bill that I opposed when I wasn't in this committee, which would allow lawyers to sue. And that's the deal in workers' comp. You take it, but you can't sue for damages. It's a very restricted system, and premiums are restricted. So I don't know. We're gonna have to move on because we've got 2 more bills to get out tonight. So Senator Hardy.
I'm fine with moving on. I just see that Maria posted a comparison of proposals that includes a possible third option, and I don't know that we've discussed that yet, but.
No, we have
Yeah,
not.
so I know we don't have time, but.
We're working our way through and we're spinning our wheels. When we first took this up, and FX volunteered to tell us what actually happened, and because we were kind of at the same crossroads as to how do you do that. And Maria, do you have a suggestion that might get us out? I really do. I think I'd like to do this more like on Thursday or Friday when we've got some more breathing room. Because this one, I don't know if we're gonna get out this year, and I know, and if we do, I don't think it has to go to a probe. So I'm trying to get those big bills out. So maybe we will stop with this one. We got EC Fibers in testimony, and thank you, gentlemen. This is helpful.
Frank, may I just say to Senator Hardy, I think we have attempted to be responsible.
Yes.
And I feel bad if you perceive us as not having been. We have tried very hard to serve the community and everybody whose property we pass well. And we did all the things that ought to have been necessary had we been dealing with responsible parties all the way down the chain. Thank you.
Yes, I guess, thank you, Irv. I appreciate that. I guess I would just encourage you to make sure that you're dealing with responsible parties all the way down the chain. And I'm sure you try to do that, but there's a lot of fiber going out in a lot of places in our state right now. And a lot of deals are being made. and it's happening quickly. And I just hope that we aren't going to see more of this kind of thing happening because everything's moving so fast.
Amen.
Talk to Christine and the board.
I just have a factual question to try to understand the timeline. My understanding is that the subcontractor who actually left the problem had insurance, and was the insurance canceled before the event happened?
The contractor worked on this particular job, which was to run fiber across several miles of off-road easement poles. And it took them, I don't know, 8 or 10 days over a 2-week period to get that work done. And toward the end of that process, their insurance was canceled for non-payment.
Okay. Now, was the prime contractor notified of that? Did the prime contractor require, as part of the contract, to be notified either as an additional insured or notified as the prime contractor, so that in the event of a cancellation, there would be a notification sent to that person? Did that happen?
That is not something that I can't answer that question. I do not know. I do not know.
That's the normal practice, to have that happen.
Well, yes, theoretically. And if that happened and the note, and the notice went to, and the notice was sent out, and then it arrived in the mail 2 or 3 days later and he was done with the job, then you just have a gap in time.
I mean, that's a fundamental question, because the real question I'm asking is about what's the risk management within your process, so that in the event that a subcontractor is without insurance, thereby creating a risk all the way up the chain, was the chain aware of it? And did the chain have a process that required subcontractors to include their insurance company with a notification requirement in the event of a cancellation?
Well, I can tell you that nobody on the district board or at ValleyNet, knew anything about any of this until May 25th, 2021.
What that sounds
We
like.
will find out.
based
We
on
will
what you
find out.
said,
No, we're
is
not
that
going
there's a breakdown
we're not
in
going
the
to,
internal controls between you, the contractor, and the subcontractor, if there was no notification provided, or if it was provided and lost. That just seems like a fundamental breakdown in internal control to me.
okay. Clearly, Eustis should have required of its subcontractors that they be a named insured, and to force that. And
And that would be the kind of thing that I would expect that you, as the owner, would be mandating, that in the future, that any prime contractor requires their subcontractors to be additional insured, and in the event of a cancellation or issue like this, that the notification goes up the line. That's pretty standard.
that's in the contract, but it didn't happen.
And if it didn't happen and you didn't get a notice that you were an additional insured, what's your internal control to know that you didn't get the notice?
Well, we have a contract that, puts the liability back on them, and that would be one of the things that we would point to.
But the point is, how do you know? For example, an insurance policy gets canceled and none of you up the line apparently knew about it. That is a fundamental breakdown in internal controls.
Right. Happens all the time.
So, I would imagine that would be something that would be taken care of, first and foremost at the level of our prime contractor, right? And then they would have to deal with it. Now, would they, report to ValleyNet, and then would ValleyNet turn around and report to the district governing board? We're out there having our board meetings once a month and our subcommittee meetings. We are not involved in the day-to-day business, Senator.
Well, all I'm saying is that fundamentally, somewhere along the line, in terms of the controls, you know, if you have a process in place to have yourself or your prime contractor listed as an additional insured, and that doesn't happen, their internal controls should have picked that up.
Yeah.
And dealt with it. And apparently from what you're telling us, they didn't.
I-
So the problem is not solely with the contract, the subcontractor, it's also with the prime contractor.
Yeah, I don't disagree with you. And you might want to invite some utility contractors to come in and talk about how they deal with this.
Okay, I'm gonna have to wrap this up because our question is there something we can do that will prevent, in the event of a bad apple, the victims out there being strung out for a year or more waiting for compensation? And that's really what we're trying to do. Senator Sirotkin, quick question. You're muted, Michael.
Thank you very much, Madam Chair. I'll keep it brief because I heard way back in this conversation something about the attorney for the plaintiffs in this case, the Hoyts, I guess, sees some optics in this case and maybe asking for a very large number. Every case in law has two elements, liability and damages. And I would ask Maria if she could talk to some of these folks and if they will reveal what is the sticking point here, because it sounds like everybody's sort of admitting or there is insurance players to pay the money, but maybe the real sticking point is that the money that's being asked for is so high that it's getting in the way of a settlement. And it may not be that the insurance companies haven't agreed on how they're going to divvy up the liability, but that the figure that's being asked for is slowing down. And that's the right of the Hoyts to say, I want a jury trial. They're just going to have to wait. And they may get a bigger number if they go to a jury of their peers. With this being the primary example of this case, I would like to know if that's a factor on what's going on here, which is slowing everything down.
Okay.
It may be from my perspective. We looked at the claim that the Hoyts attorney sent to Kramer O'Connor and Eustace in January of 2021 for $1.1 million, and we saw that as basically consisting of provable immediate expenses that they all had receipts for, probable expenses for the 2021 farming season that by the time we found out about it, we said they probably have documentation on that. And then some more complicated claims over things like, has the value of the breeding animals been compromised, and what's the value of that, and is there land remediation that's going to be necessary, and what's the cost of that? And so our proposal, and we had all the people on our side together by the early September, was that we had this three-part approach. There was some money we could put on the table right away, more money we could put on with some documentation, and then we would get some experts together to sort out the rest. And their attorney had said, let us know, when you're ready. I'm not going to file suit, until the fall, and I'll show you what I'm going to file before I file it. And so in early September, we said, okay, we're ready. And then he put us off, finally said, okay, we'll have a meeting on, Wednesday, November 9th. And so we all showed up at that meeting, and he opened up with saying, on Friday, I filed a lawsuit in court. And you could just see the air go out of all the other, attorneys and insurance companies. And it just immediately became an adversarial situation. And I was kind of crushed and,
Okay, we're gonna have to cut this off
Thank you,
because
Madam Chair.
we can't retry or try this case. The question is, what can we do, if anything, going forward? And we have 2 more bills to get out. One is the timeshare valuation, and we wanted, before we did anything, we wanted to hear from Rebecca Samarov from the tax department. And Abby is here somewhere, and the question I think that got proposed, other than take a look at it and say what you think, was the raise to $1 million adequate? And, or should it be more? Given that that's coming out of the ed fund, it has some issues too, but so we've got Rebecca. I'd like, if possible, to get this one out tonight, because I know it's got to go to approach, and I'm trying to spare them late nights next week. So Rebecca, what have you got for us? And I understand you had some other tweaks. Thank you, Mr. Flynn, Irv. It's been helpful, and it's good to know that everybody was, except maybe one guy for 2 days, was doing what they were supposed to.
That's all it takes.
You know, it's all it takes. Well, no, it's attorneys and it's insurance companies, and that's the system. So Rebecca.
Hi.
Thank you.
Rebecca Samaroff, the Deputy Commissioner from the Vermont Department of Taxes. Great to see you guys all in the room again, or some of you at least. So I'll just jump in on that question about $1 million being enough, but maybe in the meantime, the committee can find the handout that Faith has either passed out or posted, or I think, and both posted on the web under my name.
Posted, or she emailed it to us.
Great. So yeah, short answer is, yeah, we do believe that $1 million will be enough to set the cap in at initially. We're, would be totally fine if the committee wanted to, welcome us back in a year or two to, check in on that amount. But 1 million was the amount requested by PBR back in 2017 when we moved away from the old system. It's, even with the Sheldon Dam situation that I know some of your members are familiar with this year, we anticipate that'll be more than enough. Over the last 4 years, it's kind of hovered around, hovered pretty low. This last year was the first year that we had to prorate the requests because they came in just over $100,000. We had to prorate them at 70%. And there were 9 total requests there. So we are feeling confident that cap is a good one for now.
Okay, Senator Brock.
Well, one of the issues that we've also been talking about is legal expenses associated with that, and whether or not we should amend the proposal to include legal fees, because one of the issues has been our towns discouraged from filing appeals in cases in which they may expend significant amounts of money for legal expenses that may or may not be reimbursed. Do you have an opinion?
Yeah, I think that's a really good question. We didn't consider incorporating legal expenses into this for a few reasons. Just in general, even before 2017, I don't believe that the 5412 mechanism was ever intended to reimburse the expenses associated with, like the legal mechanics of the appeal. And it would also just open a whole new category of eligible expenses, which would be much harder to evaluate for the type of expertise we have at the tax department, which is a little different than that. The best practices, bar for the appraisal is hard enough, but having us determine like what are reasonable litigation expenses, we won't want to be making the call of the tax department whether like a legal fee felt excessive or not. I think overall this is, we're getting into just like questions about our big complicated property tax system that has, a lot of local responsibility. And I think that raising this cap makes like a really, meaningful iterative steps towards improving the situation for towns. This reimbursement mechanism is one, the litigation and appraisal support through the other mechanism that this bill considers is another one. And it seems like, I don't know, this seems appropriate to keep it limited the way it is to us at the department, at least.
Well, some of the testimony that we heard was that many towns are reluctant to actually file appeals because even if they win, and they very well may not, that although there's a mechanism for them to recover, where we even had the $100,000 limit, the problem is the legal fees could be very substantial. And so as a result, it served as a damper that discouraged towns from going after situations that might result in an appeal. And that was one argument perhaps in favor of providing some relief, because you get these very small towns, and these cases, as you can imagine, can be tremendously costly to litigate. What does a town do?
Well, I think the purpose of this bill is to do everything we can to ensure the towns don't get in there. We've got,
Absolutely.
The expert help to value, and I'm thinking it could get very expensive if people could hire New York City lawyers to come up and litigate, because I don't know. I know I got some heart palpitations on the 800,000 for the per parcel fee increase, and I'd like to get this through and then see how the new system plays out. So Senator Hardy.
Yeah, I guess I hear you, and I'm sympathetic to those small towns. But I agree with the chair that sort of there are other provisions in the bill that are trying to get at that. And I would feel uncomfortable if we open up the education fund to pay lawyer fees, because these are payments from the education fund, and they're supposed to, offset losses in property value because of appraisal differences, but adding legal fees to it opens up a whole other kind of payment from the ed fund that I would not be comfortable with.
Well, as I say, the point that you have, though, is you then create an environment in which you discourage towns from fighting appeals in the first place.
Right, and I think that we're trying to change that environment through other provisions that wouldn't.
I think that might be part of the plan, though. If you could appeal everything and avoid sending the money to the ed fund, towns just might do that. I think I know. I come from town. I don't think they would, but some people in this building do, and we find ourselves doing that. Senator McDonald.
Senator Brock has said the owner of the property hires a New York City lawyer.
No, I said that.
Forgive me.
Reasonable attribution to my mark.
New York Day.
I'm gonna be in trouble with New York City lawyers.
And because the lawyer is being hired to win the case to the client. The client has a big dog in this fight. The town doesn't have the town's interest in defending their position, their appraisal,
I get it.
is only the size of the municipal budget. And they'll turn around and drop their rifle and run off like the Keystone Cops a lot quicker than the one that hired the New York lawyer. And the ed fund suffers. And the calculation that ought to be made, and I don't know if we're capable of making it, is the ed fund going to lose more money or less money if we help the towns make serious
Senator,
appeals?
we had this conversation yesterday, you explained it, and there's other provisions in the bill that address this.
Okay, I
I'm
think
ready to learn. Thank you.
Rebecca or Abby, there were some more tweaks to this.
Yeah. So if folks wouldn't mind pulling up the document I prepared and.
Can you share that screen?
Oh, yeah. Oh, yes. I have not done this on Zoom in a while, so let's hope I don't do something embarrassing.
Yeah, this is a whole new system to us.
Okay. Okay. Does this look like a Word document?
It does.
Oh, hey, look at that. Okay.
I've even got that on my screen.
Is it still
Okay.
there? Oh dear. Did I pause it or is it still working okay?
It could be a little larger.
Okay, let's go. We're gonna put it back where it was before. And make it bigger. All right, how's this? Is that a little better?
That's better, yeah,
So,
better, okay.
So, and I will say that I shared these ahead of time with Abby too. So if the committee were open to adopting some of them, I'm hoping we could have a new draft ready really quickly. Everyone could still vote and be happy. So that's the goal here, I think. So the first thing, these are some of these are really small edits, and then there's also just a recommended insertion. So this first one, eligibility for state appraisal and litigation assistance, we were just hoping that the language around setting the eligibility conditions would apply to the parcel itself and not to the municipality as a whole. Like wholesale writing off a town from eligibility wouldn't be as desirable for us. And we'd like to instead create eligibility conditions for characteristics of the property, which might very well include characteristics of the town that it's in. But, you know, kind of like the point being that towns may be good at valuing various categories of property, but if they have something very unique, like a mall or a factory or a defunct mall, you know, they might not have the expertise for that. And that might be, you know, a perfect opportunity for them to apply for something like this. So that's recommendation number one. I'm happy to take any questions there.
Any questions? So this would be based on the characteristics of the property, not the characteristics of the town. Okay, because you don't want to have to be doing a general store just because the town only has one and it's new.
Right, yeah, or just say that like a whole town is ineligible for some reason when, you know,
Yeah.
something really unique could be happening that they don't have the expertise for.
Okay.
So let me scroll here. If there's no other question, this one's a little longer, but we would like to recommend new language around routing appeals that would involve these kind of properties when they're, so basically if there was an appeal that of a commercial value that the town or that the department assisted the town like through this mechanism, we'd like in that case for it to be directed straight to the Superior Court and bypass our PBR hearing officer level. Our PBR hearing officers are more specialized in residential property. They're really good at, you know, like evaluating comp sales, stuff like that. Like the system is really akin to like a small claims court for property. And the process was really more set up for folks to have an easy appeal without necessitating, you know, like getting a lawyer or going to court. And so it's really not an appropriate place for big complex valuations of any kind. But in this case, we would just like want to make sure there was a wall of some sort between, you know, a PBR associated hearing officer and a PBR associated value, you know? So the recommendation here, I can scroll down a little bit more, is just to add this language giving the PBR director discretion to direct some cases away from the hearing officers and directly to the Superior Court. And there's another plug of language down here. Any questions here?
I'm not seeing any. Questions?
Awesome. All right, the third for your consideration, this one's a little more nuanced, but This recommendation for the appraisal and assistance program came straight from our January valuation report. And that recommendation was really conceived to handle unique commercial property, but the report considers a different kind of more holistic direction for utilities specifically. So I don't want to take too much of the committee's time on this now, but very much encourage you to read the January report. But, big picture, we are doing work in PBR right now to pursue improved valuation methodology for utilities, which we use for the equalization study, and then towns can use themselves. And we're hoping the next step, which we're working on in with utilities themselves and with input from towns, is to come back to the legislature and recommend a more streamlined approach where we would really just remove the burden off towns completely for setting their own utility values, and they could just rely on these state values. But we're doing the work in-house now to make sure our state values are good enough for a program like that. So this process is very much underway. And removing this word is kind of more of a signaling that we're committed to this other direction with utilities. I do just want to note that removing this word doesn't seem to legally preclude us from supporting a town who has a tricky utility property, because a utility property is certainly a unique commercial property. It would just be our preference to pull that word out here to kind of maintain some consistent messaging with the direction we're going around utility appraisal.
Senator Brock has a question.
In terms of the consistency, even with the word utility removed from this particular paragraph, the total amount of money in the $1 million would apply to all complex projects, including utilities, even with that word deleted. Is that correct?
Well, this is sorry, I don't have this language situated in its section, but this is actually for the state appraisal and litigation assistance program, which is separate from the
recovery.
Yeah.
Okay, thank you.
Yeah, sorry, my document is not very clear in that respect. I'm sorry.
Okay, Senator Hardy.
So Rebecca, with this, as Senator Brock's district, the property in Sheldon is a utility property. There's a property in my district that would be considered a utility property. I think a lot of these are utility properties. And so I'd be concerned to remove utility from this and have nothing there while you're trying to work out some other thing for utilities. I guess my preference would be to leave this word in for now so that there is some kind of placeholder, if nothing else, that there's a mechanism for towns to come to you for assistance with utility valuation. And when you are able to get the other thing up and running and you come back to us with a recommendation, we could then amend this hopefully that by then existing statute to take out utility.
Yeah, so a couple of thoughts there, if you don't mind. Like one, we do actually have a program akin to the state appraisal and litigation assistance program that's conceived here specifically for hydro dams already, and that was a kind of the model that we
yeah, but they're not all hydro dams, and mine is a digester in Senator Bray's in my district. So I think that those are the kinds of properties that come up all the time, and I'd rather have a mechanism in statute now for them, or when we do this bill, if it should pass. And then if it needs to be amended in the future because you've come up with something else, we could do it then. But there are towns right now that need assistance with valuing utility properties.
Mm-hmm. So I think of utilities, and the ones we've had trouble with in the past are poles and wires, which are not unique properties. They're everywhere, but towns seem to have issues.
Yeah, so
what you're saying is you're working on something with utilities, and that would probably, but that something like a digester would be a unique property.
Yeah, so one thought I have, which I would love, Abby to weigh in on, is our legal reading is that we could still absolutely assist a town with a utility property without having the word here, just because utility property is, definitely falls into other unique properties as a category. And I guess just a feeling is we don't want to suck the momentum out of the out of the chamber to address our utilities in kind of like a bigger, more uniform way, especially because that way that we're conceiving is taking the burden evaluation off the town. So it seems a little indirect from us to be moving, and this is a short-term move. We're hoping to have something for you guys next session, moving to a situation where the towns are completely, out of the business of valuing these themselves. It seems kind of, like an extra step in the wrong direction to then give a bunch of valuation assistance and expertise to the town, really beef up their local value if we're about to come through with a mandated state value that they'll be using. Does that make sense? I don't know if I described that very clearly. That's our thinking here. And, it's not a deal breaker by any means, but just a request.
Yeah, thank you, Madam Chair. I guess I would prefer to keep it in here for the reasons I stated and that we can take it out. This program would, based on the way the bill's drafted, wouldn't go into effect until July 1st of 2023, I think. Anyway, so if you do come back with another proposal, we can certainly amend this and get rid of the word utility. But if we take it out now, I'm a little leery based on being bitten in another area that there could be the interpretation that legislative intent was that you would not assist with utility properties. And so if something happens and you don't come back to us with another thing next session, I want the word utility in this law so that towns that do need assistance with utilities can use it in the interim. And that there's not a question that that's possible, even though your legal counsel says without the word you can still do it. But legislative intent gets interpreted bizarrely sometimes.
Senator Bray and then Senator Brown.
Well, I was just thinking to Senator Hardy's point, the fact that the word is here and then being struck could create, unfortunately, an argument on the part of others that utilities explicitly were considered and removed by the legislature. And so again, it's a gray area, but it seems like to keep it seems like a sort of a solid belt and suspenders move to avoid confusion over legislative intent.
This is not our last stop. Senator Frost.
Well, just a question. You had mentioned the effective date of the bill, and I hadn't noticed that at all. Is the effective date the entire bill, July 1 of 23? Is that right?
Okay. I'm watching chats. I'm trying to figure out if the Senate office is open. So if we vote bills out, we have somewhere to send them. They're not answering emails, so it looks like.
Yeah, this is a question.
You just saw them going. Okay, they're gone. So
the question was for Rebecca.
Oh, I saw Abby. I'm not super familiar with the effective date besides our.
Abby could answer it then.
Effective date, yeah.
Yes, I'd be happy to answer it. So for the record, Abby Shepherd, Office of Legislative Counsel. The Act's default effective date is on passage. So there are different effective dates for the change in the cap for the refunds to municipalities. That's January 1st, 2023. So it would apply to any final appeals or cases decided this year.
Okay, that's all.
And then, yes, I'm sorry, I didn't hear the.
I said that was the question that I was really interested in answering. So thank you very much.
Leaving the word utility in, are we fine with these tweaks?
Yep.
Okay, so then I'll ask Abby to draft that up and we will vote this out tomorrow. First thing, and then Abby is here because she had one little tweak to S53, right?
Yes, that's correct. I do, as I had received language from Rebecca earlier in the day, I do actually have a draft ready for the committee if you wanted, but I don't know if you would like a break or would like to consider it tomorrow.
I think I'm starting, we've lost the Senate staff, so we could vote it now and whoever is the reporter could take it up in the morning. If we get S53 out of here, we can take it up in the morning because they're not there.
The morning? Are we meeting in the morning?
No, but we'll
Oh.
have to, you can't take the bills up now, so they should go up first thing in the morning.
Right, oh, okay.
There have been issues with bills that disappeared into coat pockets for numbers of hours and days, or got rewritten, but they should go up first thing in the morning. So, do you want to vote this one out now or wait till tomorrow?
It's ready.
It's ready? Okay.
Do we, Abby, do you have it with utility struck? Or
No,
maintained, I
utility
guess?
is in,
Utility is in, from my understanding of your discussion.
okay?
Is that correct? Okay.
I should have
I'm-
said the change to utility is struck. Sorry, you've got
You have not followed the deputy commissioner's recommendation.
Stop confusing things, Senator Pearson.
I assume,
I-
oh, good.
Abby knows what we did.
Amazingly.
You can email that to the
We can do
committee
this at
and
10
then,
o'clock at night, it gets even better. My goal is to not do that. So let's get this one going and then hopefully we can get S53 out the door. Yeah, this is
214.
214.
yes, I've
And
just
Abby
emailed it,
writes the draft number.
draft 3.3. And this, so the language I just emailed, I'm unable to share my screen.
Okay.
But I did just
My
email it to the
battery
committee
is
and
low, so
Faith.
I'm in trouble.
Abby, if you don't mind, draft 3.3 date, et cetera.
The date is today and the time is 5 PM.
Thank you, Abby.
So this draft does include the word utility. It makes the changes so that a municipality would apply for the state litigation and appraisal assistance program for individual properties. It wouldn't be a wholesale approval for an entire municipality. That was one of Deputy Commissioner's recommendations. And then the other new language is relating to the director of PVR's authority to forward appeals that are very complex to the Superior Court. So there are two sections with the language that the Deputy Commissioner showed you. It's identical in this version.
Yes, Senator Pearson has a question.
Yeah, I'm sorry to do this, but Rebecca, the change to property for municipality, is there an intersection there with the $1 million? Are we suddenly opening it up to be many $1 million or no?
No, that again, and sorry, this is like an issue with my document. That's referring to our litigation appraisal program, which is outside of that.
Okay, thanks. I just wanted to be sure. Thanks.
Yeah. I assume at this juncture, the committee doesn't want to talk much about the per parcel fee piece.
So can we have, I know that it's late, but could we just have Abby walk us through the draft quickly
Yeah.
in order like we
Yeah.
do in
Yeah.
welfare, just so we
Yeah.
know everything that's.
So
in it.
Abby, walk us through it, just, 2,000, 10,000 foot view. Just.
Yes.
Section by section, so I can follow it, that's.
Yes, I'm going to try and share my screen. Faith has given me that ability. Just trying to find the right screen. Sorry. There.
Okay, you make it a little larger, we'll.
Just start from the beginning. Okay. So this is draft 3.3. I can
Make
make
it
it
larger.
larger.
That,
Is that better?
yeah,
Okay. So this is the strike all amendment to the timeshare valuation bill. So the first section increases the cap from $100,000 to 1 million, and it's again prorated across the state. Again, that is only for reduced values of the grand list values. It does not apply to litigation costs. The second section creates a new state appraisal and litigation assistance program created within the Division of Property Valuation and Review. As you'll see here on page 2, the word utility is retained. So it is to assist municipalities with the valuation of complex commercial, utility, or other unique properties. And then on line 6, there has been a change, I'm sorry, on line 7, a change to subdivision B1, so that the commissioner is required to determine the conditions for a property to be eligible for state assistance. Previously it said a municipality. And then there is language here that I added just to clarify. And in fact, as I'm looking at this, I might suggest that this word parcels be changed to properties, just to make it clear that when a municipality is applying for assistance, it's for one or more properties. So I could make that change if you are amenable, just to make it consistent with subdivision 1. Section 3 requires the Commissioner of Taxes to provide a cost estimate of how much this new state appraisal and litigation assistance program will cost. There's been no change to the previous version you saw of this language. It requires an estimate of upfront and ongoing operating costs for creating, implementing, and maintaining a new state program. The next 2 sections are the language that the Deputy Commissioner just proposed, and I'm going to scroll down slowly, so hopefully it won't make you sick. This is the subdivision where a taxpayer can appeal their property valuation from a decision of the Board of Civil Authority. There's a new language being added at the end of this subsection, which gives the Director of PVR the authority, if in the Director's opinion, an appeal involves a complex or unique property or valuation that would be better or best adjudicated by the Superior Court, the Director may decline to assign a property valuation hearing officer to address that appeal, and instead the Director would forward that appeal to the Superior Court. And then the final sentence makes it clear that an appeal would be considered timely filed with the Superior Court if it was timely filed with the Director. And then section 5 goes on to it's sort of conforming language to make it clear that the Director refers an appeal to a property valuation hearing officer only if it hasn't already been determined by the Director to be so complicated that it should go to Superior Court. So you have the cross-reference there. So those are the main new sections. The section 6 and 7, the ordering from the last draft that you saw has changed slightly because I tried to keep subjects in the same order. Section 6 repeals the $8.50 per grand list parcel fee that was used for, or is currently being used for reappraisal and maintenance of the grand list. A part of the concern with this section is that it requires it to be paid from the ed fund, and it's since 2018 has been paid from the general fund. That said, in section 7, the $1 per parcel fee is being increased to $12, and the uses that were allowed for the $8.50 fee are being added into this section. Section 8 is back to the timeshare issue. So it requires a report from the Commissioner of Taxes next session about what other states are doing with timeshare project valuation and options and potential legislative language to address the complexity of valuing timeshares in Vermont. And that's the end of the substantive sections. The effective dates are, as I said, the default is on passage. And then 2 sections are given special effective dates. One is for the increase in the cap on refunds to municipalities that takes effect January 1st of next year. So it would apply for decisions made this year. One decision of interest is the Sheldon Hydro decision. In subdivision 2, the state appraisal and litigation assistance program takes effect on July 1st of 2023. So that provides time for the department to start up that program. That said, there is this contingent effective date provision where the new program will only take effect if the General Assembly appropriates funding to cover the department's costs. And finally, because the title of the bill was previously relating to timeshare valuation, it has been expanded to an act relating to valuation for purposes of the education property tax. I'll stop sharing.
What's this committee? Senator McDonald.
What time of year do appraisals, questioning the appraisal, asking for a hearing or appeal? What's the deadline? I thought that was after April 1st in June.
I'm not sure about the answer to that.
I don't know off the top of my head either. I'm looking at the statutory language in front of me, and it does say it has to be within 30 days after entry of the decision of the Board of Civil Authority. But I don't know exactly the
I was wondering
timeline.
what the practical effect of starting it on July 1st of 23, whether we were losing 1 year or 2 years or what. That's it. We can always make a change later. if we-
Going to the other body.
If we,
So we could, if we find there's an issue, there is a deadline for appealing once your appraisal comes out at the town level. And then this would take over 30 days after, right?
That's right. I just don't know the dates off the
Yeah,
top of my head. I can get you that
And
answer.
some are doing tax appeals, but
plenty of time to change that.
Yeah. okay. Committee, what is your pleasure?
To vote
Nobody
the
wants to
bill.
go.
I'll make a motion.
Wait, you changed parcels to property?
Yes.
Yes, I can make that change.
Okay.
I'll move, and it would be would it be now a different version, Abby?
Yes, please. Let's make it 3.4, same date, March 9th.
3.4 S214 3/9/2022, 5 p.m. Got it?
Yeah.
Okay.
Okay, moved approval. Further discussion? If not, all those in favor say aye. Opposed, say no. I believe that was a motion
To
to
amend the bill.
amend the bill. Now we
Yes.
need a motion to pass, approve the bill as amended.
So moved, Madam Chair.
Senator Hardy moves. Further discussion? If not, all those in favor say aye.
Aye.
Opposed, say no. That carries 7-0. Wait, yeah, Michael's there, 7-0-0. Okay, thank you, committee. Somebody want to volunteer on this one? Senator Hardy, it's your
I'll do
bill.
it.
So to give
Senator
someone else a
Westman might
chance.
kill me.
Okay, we have S53. We want to do that tonight. We were changing that one word on the retirement. This is the corporate income tax, and remember, we asked Abby to go back and say for the municipal, for the civil service people, they were the same as military. We were treating everybody the same. Do you want to do that, or would you rather wait till tomorrow?
Let's do it now. There's only
Okay.
one word. We just talked about it.
It was, Abby, you were able to make that change. I'm not even gonna ask you to put it up unless you can.
It
you
is
said it
more
was-
significant than one word, just to be clear.
Yes, it's,
One concept.
Well, it probably is useful for us to see what we're
yeah,
voting on.
let's see what it is, if you could share that. And I should probably tell Faith my computer is charging, so don't. You'll have to break in if you need to send me a message.
So would you, let's see.
Let's just see if
Trying to think of the best way to, may I just share my screen with you for
Yeah.
the portion that has changed?
Yes.
Okay.
Yeah, I think we went over this an hour ago, may seem like a year, but
It might seem familiar.
might seem familiar. Okay, here we go. There's the change.
So there are several changes within section 8. That's the only part of the bill that changed following your discussion. So what this does is it retains the structure where there are sort of 3 different new types of exclusions. In the civil service retirement system income subsection, it adds this highlighted language, just that in addition to setting out how the exclusion will be determined, the income will be subject to the limitations under subsection E of this section. I've done the same in, sorry, I'll try not to scroll too quickly. The same language has been added into the other contributory retirement systems. They're subject to the limitations under subsection E of this section. And again, the same addition has been added for the military retirement income subsection. Previously, that was the only subsection that had this limitation. It is now in subsection E, which says that a taxpayer of the state who was eligible during the taxable year for the Social Security income exclusion under subsection A of this section, and any of the exclusions under subsections B through D. So that's the civil service retirement system, other contributory retirement systems, and U.S. military retirement income. If a taxpayer is eligible for both of those and both Social Security and those other exclusions, the taxpayer shall elect either one of the exclusions for which the taxpayer is eligible under subsections B through D, or the Social Security income exclusion, but not both for the taxable year. One thing to note is this leaves it open for the taxpayer to change each year. They can decide. It doesn't sort of lock them into an election forever.
Okay. Committee.
This is why tax policy is so complicated.
Yes. It's exciting.
So we're getting to a 2-letter form. You need to put your adjusted gross income on line 1, and then line 2 is pay the amount on line 1.
Aw,
Abby, please don't
that
go
was
away.
simple.
After we vote this, I have to get the right draft and date on it, okay?
Sure. So this, I believe Faith has managed to post all of the new documents. This is draft 2.2. It has today's date and it's 3:59 p.m.
3-5.
At what time?
3:59 p.m. and it's draft
Thank you very much.
2.2.
Okay. So is somebody ready to make a motion on this one? Nobody? We're gonna sit here and not go home.
Madam Chair, I'd be glad to move this amendment.
Okay, so we're good. The motion is to amend the bill as just presented. So further discussion. Do we have to do that? No, because we're amending the whole bill. So we've changed the amendment that we're using. So this version is
2.2, 3/9/22, 3:59 p.m. Incorporates all the things we have discussed,
yes.
including
The last
previous
one,
draft.
so we're moving to amend the bill as introduced with this draft.
Yep.
So I need Senator Pearson, you did that motion? Okay, further discussion? If not, all those in favor, say aye.
Aye.
Opposed, say no. I didn't hear any no's, so I'm gonna call that 700. Now, I need a motion to approve the bill as amended.
So moved.
I got Senator Pearson. Okay, further discussion? If not, all those in favor say aye.
Aye.
Opposed, say no. I'm hearing 700. Okay. I would like to present this one, unless somebody else is happy to do it. All right. Abby, since the Senate office is closed, if you can get me a clean copy tomorrow morning, I'll bring it up, and I guess Senator Harvey needs the same thing on that last one. And
Well, that's the question. Aren't we allowed to still email them the drafts like we did?
I don't think so. We'll check with them. The normal procedure is the presenter of the bill has to walk it.
Yeah, no, I know
personally
that was
there.
the procedure, but I don't know.
And they're not there for us to email them tonight anyway.
Okay.
We can ask John when we
Well,
go.
I just emailed them about 214, so the one we just passed, but
Okay. I'll bring it up in the morning.
I can bring it if you, did we actually update a copy from Abby or to print one?
The normal procedure is we get a copy and we also get this card and you have to initial it and write the vote.
Okay. Will you get us those in the morning,
I
Abby?
think they have the things upstairs.
Yes, I've emailed the S214 to the committee, and I'm in the process of emailing the clean copy with no highlighting of S53. And I will also be sending out side by sides for the reporters and section by sections.
Okay, and if they can run me off a copy in the morning and or we'll get it here. Okay,
How many more bills would you like to do, Madam Chair, today?
Well, we're at,
I think we're done.
Yeah, we did pretty well.
We are known for sending them out the end of the year. Next, I don't know. Senator Sorokin, what are you sending us next week? Omnibus bills make me very nervous.
You'll get on, we turned in a housing bill this morning, so it should be referred to you tomorrow.
Okay.
You mentioned hunting bill from,
Senator
No,
Cummings, are
no,
you
no,
ready?
No hunting bills.
all you,
Yeah, we need to go off live.
Preparing to go off live.